There are many steps in a criminal trial. Obviously, you get to that point by there being no plea bargain deal. So first, the defendant would go to trial. They would have the discovery proceedings. That's when the defense and the prosecution exchange evidence. That would be after the decision to go to trial. There are motions filed. This can be before the trial starts, things to be kept out of court. It can also happen during the actual trial. There's the opening statements. This is a summary. Each side gets the chance to do it, a summary of what they're going to present and kind of the start of the story they're going to tell. Next would be the prosecutor's case. So this is the government's case. This is showing the evidence, telling their story, presenting their witnesses of why it is the defendant that did the crime, committed the crime. Next would be the defendant's case. So this would be where the defense attorney could put on their alibis, their experts, to prove that there is some reasonable doubt that something else could have happened. After this would be the prosecutor, the rebuttal. They would bring on new witnesses or present new evidence to show why the defense's case is incorrect, why their alibi witnesses or whatnot are in error. Next would be the closing arguments. This is, each side is going to summarize, really it's storytelling to really lure in the jury to believe their story. Then the judge will give the jury instructions on what is expected and legal guidelines for the deliberations. In the deliberations, the jury going over all the evidence, talking out the case, coming to a conclusion, all in a private room with only the jury. And then the verdict. This is the jury's decision. This is given to the judge, and the judge can go through and ask, if the attorneys want, every single juror if this was the decision that they made.